All right. Thank you so much, Morgan, for being here.
Thank you.
Great. Well, good morning. It's nice to see everyone or their names. I know it's been quite a long time. So I just did a brief update for the probate court. It'll be a PowerPoint, and then at the end, we'll have a discussion. If you have questions, concerns, etc., please, feel free to raise your hand, or if you aren't Zoom savvy, you can go into the chat box. So I'm going to attempt to share. All right, so first and foremost, I have to thank all of you. It has been one insane year and a half for us here at the court and for you all practicing. We've made a lot of changes, additions, some great, some not so great, but we really couldn't have done it without the support of the bar and everyone's willingness to jump in and do what we had to do. I'm proud to say that the probate court never closed during the pandemic. We always had staff on site handling emergency matters, and we were open to the public. With that being said, it's a good thing to say we don't have a backlog of trials, etc., because of that. But again, it wouldn't have happened had we not had the support from the bar, from all the attorneys, and people willing to go with the flow with us. So from me and Chief Judge Garcia and Judge Dennings, thank you very, very much. All right, so I thought I would start off with case type codes. And why am I starting off with case type codes? Because it's so important that we have these on our pleadings, but also if there's new attorneys who aren't familiar with Ingham County, to understand what we do handle and what we don't, because each probate court is different. So for example, we do not handle delinquency matters, abuse, neglect, adoption here in Ingham County Probate Court. Those are in circuit court. So again, if you're filing, you need to make sure what court you're doing it. And if you have the correct case codes, it will be rejected if you don't have that. We can't have staff, guessing that this is a DD case or a GA case. It gets us into some major trouble. So please remember the case type codes. All right, updates. So current COVID updates. During the summer of 2021, SCAO moved all courts to phase 4 automatically, which meant that we were pretty much back to pre-COVID operations, all boots on the ground. If people were able to work remotely, that we should allow that. Currently, with how our system's set up, we have to have people on site for a lot of our duties, like docketing, etc. Currently, per Chief Judge Garcia, masks are to be worn in public areas of the courthouse. So, the lobby, the screening, the courtroom, unless otherwise directed by the judge. If you see staff who are behind the glass not have their mask on, that's because Judge Garcia has said that if you are vaccinated and you are an employee in a private area, then you are not required to wear a mask. You may see employees still wear masks because they choose to do so. So please don't be alarmed by that. We do not have any more pre-screening. So you used to come in and get your temperature checked. We don't have that anymore. And while I am not, this makes me sad because I thought it was great, but effective July 1st, we no longer have filing by email. I think it was a really great and useful tool. It was difficult for the staff to manage all the time. But at the same time, I think it offered a huge benefit to the clients and the attorneys out in the field. But again, by the directive of the chief judge, there's no more filing by email. That should be a no, not a mo. Zoom hearings are continuing with specific uncontested matters unless otherwise directed by the judge. So I have to refer you all to the website to see if that's changing as to what judge is permitting you to attend and remotely or in person. Rule of thumb is if it's contested, plan to be here unless you get permission from the judge. You can file in person or via mail. For those that haven't been into the probate court, You might have noticed we have a huge change in our lobby. We have safety glass put up throughout, a safety door, no more Wild West Saloon door. We have 2 high counter stations, 2 low counter stations. And I don't know if you can see with my mouth. I wonder if I can get the little, no. If you look here, this is this table here for computers. It can be raised high and low as well to meet ADA accommodations. We have 2 public terminals for searching the records. And then again, records requests and general inquiries can be made to the probate court records email. All right, our 2 judges. We have Chief Judge Richard Garcia, who is the Chief Judge of Circuit and Probate Court currently. And then we have Judge Dunnings, who's the Probate Judge Pro Tem. There will be a new appointment of a Chief Judge. I expect to hear something in October as to who that will be. So once we know, I will certainly email the bar and let everyone know who that is. As to their staff, I just wanted to make you all aware of their names, if you didn't know their names. A judicial assistant is for Judge Garcia is Christina Siedes. The court recorder is Christina Bogart, and the law clerk is Andrew Pappas. And for Judge Dunnings, the judicial assistant is Tracy Huffnagel. The court recorder is Sheila Berger. And again, the law clerk is Andrew Pappas. They share a law clerk currently. Starting in 2022, the Board of Commissioners and the Controller recommended that we increase our staff by 1 additional law clerk. So each probate judge will now have their own law clerk starting in 2022. This is a big win for us. We desperately needed that. I found myself going way back to old times and having to law clerk with our new mental health jury trials because we had new staff who'd never seen jury trials during COVID, and I had to take on that role. So it'll be really great for us to have an additional law clerk. All right, staff updates for our office. Sure, you all are aware that Bob and Louie are the contract attorneys for general probate matters. And then Mike Stackey is the contract attorney for mental health matters. With regard to probate court office staff, we have it separated between, it's really 6 staff members, and then myself makes 7. The caseload distribution is based on the letter of the last name. And the reason for that is so there's continuity. It's easy for the public to say, okay, I need to go to this deputy probate register versus this other deputy probate register. So for example, Missy, who's the chief deputy probate register, she has caseload letters P and Q, and then she does all the administrative work for the office. Senior deputy probate register Daniela Hernandez Perez has letters A through E. And you'll see that their extensions are also on this side of the PowerPoint, which I provided to Sally, and then I'll send out as well. You have Jeff, who does case letters F through J. And so this is regardless. I also want you all to know that it's any case type. So estates, trusts, guardianships, etc., based on the last or the letter of the last name. Carol has K through O. Jonathan has R through V, and then Aaron has W through Z, but Aaron is also the chief mentals deputy probate register. So if you have those cases and you're trying to get a hold of someone's, right away, instead of listening through the phone tree, I would suggest that you just call the extension that are listed here for those caseload letters. All right. Okay, so staff updates continued, counter schedule. And you're probably saying, Morgan, why do I even care about what the counter schedule is? I've gotten a lot of phone calls from people saying, well, they didn't call me back. They didn't answer their phone. I haven't heard back. And so I wanted to let you know how the office operates so that you can have reasonable expectations as to when you can receive a return call or return email. So our counter schedule is based on even or odd days of the week. So today is September 8th, but today's a Wednesday. So if it's a Wednesday, Missy and Aaron work the counter, which means they're not going to be at their desk to respond to your emails or to your phone calls on odd days. So tomorrow, September 9th, 9 is an odd day. Carol and Jonathan work the counter. So if you have those case letters, there's a good chance they're not going to get back to you until they're off counter the following business day, and so on. And I note this also because if you wanted to speak to a specific deputy probate register, or you were coming in to file, and maybe you have like 4 filings, for you to be aware that there's only 2 people that are working the counter at a time. And so a big plea to the attorneys out there is that if you have multiple pleadings that you need to file, if you'll email me and I can schedule a date and time with you to come and file all of those, so I can put either myself or a different staff member just to handle your filings, that would be wonderful. Otherwise, we have a huge backlog of customers, and it can get very, very difficult to manage it sometimes if someone's coming in with multiple filings. Also, during lunch, we're open during lunch. And so, but I have to give each staff member a lunch break between 11:30 and 1:30. So that means from 11:30 to 1:30, there will only be one person working the counter at a time. All right, so background check updates. I know I sent information out to the bar about the probate court now doing criminal background checks and central registry checks for any person seeking to be appointed a fiduciary in a guardianship and conservatorship case. So you might ask, well, why all this new formality? When I took over this office, I looked at different aspects of how things were run, but I also realized that there's many things that we should be doing more of, and especially when it comes to protecting vulnerable individuals. And background checks, I think, is very important. I know many other courts do them as well. We did not. We simply relied on the GAL investigation report, which, I can't imagine they have the access to the security databases that court staff could. So beginning May 1st, we started requiring criminal background checks and central registry checks on any person seeking to be appointed. So the forms are online with our packets. The forms are confidential and they are not viewable in the court file. I will note that we're in the process of formalizing a policy regarding public guardians. We do not have that at this time, but I anticipate that in the next month or so that we will have that formalized. So I'm sure you've seen this form. This is the background check form that has to be filled out. It's really the top portion that gets filled out, and then the bottom portion is from staff. Staff will run the names and 2 secure databases that we have access to. One that shows any public state convictions or arrests, and then the other that shows any type of activity related to that person, whether it's, a speeding ticket that went nowhere, a parking ticket, different civil cases. It's really a plethora that you can see all of it. Essential registry form goes to DHS, and it is checking for any prior involvement or substantiations of abuse, neglect, or mandatory finding that required you to be on the central registry list. So if we get a hit, then we ask the specific county to send over all those records. Again, those are confidential and not viewable, but the judge has all those materials prior to making a determination as to whether that person is suitable to be the guardian or conservator. I will note that you need to attach a government ID with this form. So, passport, license, sometimes you don't have a license, just an ID card, but something that verifies that it is in fact the person requesting the form or requesting the search. Okay, so as to the probate court office updates, I'm sure many of you are aware we don't have paper files anymore. We're not doing that. We're just doing the e-file, or I guess our electronic file. E-filing is the term of art. If you are needing documents from a case that is from 2013 or older, you will still need to pick up or view the paper file until we have the back scanning process done, which is a very long and laborious process. But with that being said, what I can tell you is that once everything's scanned into our system, that's our original record. So if we had a will that came out of safekeeping here, we file it and take it out of safekeeping and it's will withdrawn. And now you are seeking to file in a different county and you want us to send the will, we would actually be sending a print off because that's our original record. And SCAO has approved this, et cetera. So I just want everyone to be aware this is where it's going and where we're looking towards the future of being paperless. Again, there's 2 terminals in our office that you can view records on. And then just a little caveat is that if you're filing anything, I would love it if you could not use Staples. Staples really, we've think gone through two scanners because of staple failures. So that would be great if you could paperclip or binder clip. All right, probate court office update continued. Again, our hours are 8:30 a.m. to 4:30 p.m. We're open during lunch. This has been really beneficial for everyone. I think people have the opportunity to come during the lunch hours, but also to the staff. I will say if you're coming and you're filing, if there's any chance that you could come before 4:30, that would be great because we try to do all the countdown of the drawers, the money, et cetera, between 4:30 and 5. And remember holiday closures, Veterans Day is coming up. We're closed on Veterans Day. And then for Thanksgiving, we're closed Thanksgiving and the Friday after. And the same thing with Christmas Eve and Christmas. So the next thing is true copies. I think everyone's pretty much gotten away from this, but we don't do true copies. So you could send an additional copy in with, excuse me, something just got stuck to my arm. To conform, you can send additional copies to conform, but if you're asking for what you call is a true copy, we don't put stamps that say true copy. You'd get either a copy of what's in the court file, or if you wanted a certified, you'd get a copy of what's in the court file plus the certification. All right, so another update is that we're not doing prepayment of letters of authority. And I need to stop and say this really doesn't apply to applications because any case or filing that you're filing where something's going to be initiated or opened right away so that the letters are issued right away. Of course, you can send a separate check or prepay. Small estates is another example where people prepay. But if it's going to hearing and we don't have that hearing for 6 weeks, et cetera, I can't hold on to the money and I can't process it because I didn't actually give you something in return. And so it's really came down to an accounting issue between our offices and the treasurer's office and financial services for ensuring that we're doing proper payments, especially through the audit, et cetera. So I know that can be frustrating, but at the same time, I will say if you get the order, everything's fine, and you're like, gosh, I need the letters of authority, you can send that general inquiry to our probate court records and say, the order was entered, I need certified copies of the letter, and you can pay with the website address they send you for that, and then we can get you the letters right away. So I hope that's not too big of a hassle, but again, it's an accounting issue that we have to deal with. Okay, copy requests. There was a new LAO in 2020, raising it to $1.50 per page. For copy requests, it used to be $1, and so now it's $1.50. And if you have voluminous records, please know it's not going to get done the same day. It might not even get done the same week. I mean, we have to go down the vault to get old files and then copy them. So just be reasonable with us. We'll give you a reasonable time frame as to when to expect it. If it's something urgent, copy me on the email so that I can make sure that we're handling it appropriately and as fast as we possibly can. All right, deficiency updates. For those who aren't aware, we're required to track delinquent fiduciaries. It's called a SCAO 65 report. We have to report it biannually. It's looking at what cases are 182 days deficient or more. I have a reporting period from January 1st to June 30th, and then July 1st to December 31st. And so this has been a battle since taking this job of how to handle this with 6 staff. When our cases, we have a huge open case docket. So what we've started to do is issue deficiencies daily. So a list will come up, it'll say, these are which ones are due, and the staff will issue those 28-day notices. What I want to stress to everybody is how important it is that we're on top of this. The past practice of waiting until it was 182 days and it was on this big list, and then we do a big cattle call, is in no way beneficial to the ward. It's doing the ward a disservice. And so we get the greatest compliance if it's immediate. So with that being said, what are we looking to track? We need the inventories for estates and trusts, if it's a supervised trust, guardian of the estate, or conservatorships. We need the annual accounts, we're tracking that. And then the annual reports. Reports are for guardianship matters of the person or minor, but in DD cases, it's a guardianship of the person. You could have a DD that has both a guardian of the estate and of the person. So then you have 2 separate reporting requirements. So inventories. Inventory is a list that describes all the property of the estate or the protected person. So for PRs, you need PC 577, and that's due within 91 days after your letters are issued. The fee has to be paid before closing the estate or at 1 year after the letters are issued, whichever is earlier. Note that the inventory fee cannot be waived. So if someone comes in and they have their filing fee waived, it does not mean that the inventory fee for an estate matter can be waived, because it's based on the value of the estate at the time of the decedent's death. So at the very most, it'll be $5, because if it's 0, it's $5. But I just want you to be aware that it can't be waived. We are also, since we cleaned up a lot of our deficiency docket, moving towards estates to start cleaning up all of those as well. So for guardian of the state and conservatorships, it's a different form number. It's PC 674, and that must be filed within 56 days of appointment. So estates 91, guardianships of the estate and conservatorship 56. So annual accounts is another item we're tracking, and is very important that you pay attention to the details of the form itself. So it'll only be a supervised estate. It's PC 583, and then for guardianships of the estate and conservatorships, you're looking at PC 584. Make sure that the reporting dates are correct. Make sure they do not exceed a year. It would be fantastic if you put on the very top, first, second, final, whatever account it is. I know there's a $20 fee unless waived. And then we need the financial institution documents within 30 days after, that are dated within 30 days after the end of the accounting period for liquid assets. So we're looking to verify the ending balance with the bank statements. If we don't have the bank statements, it's going to get rejected. There's the proof of restricted account. You see these in minor conservatorships. Those also should be filed with your account. It's PC 669. However, we're not going to reject your account on its face if we don't have the proof of restricted account. Sometimes it takes time for the bank to send them directly to us. So the other thing is that you need to file the proof of service of the annual account, as well as a petition if you're filing a petition to allow. We need a proof of service at the time of filing on all interested parties. You might say, why? And the reason is the biggest backlog for our accounts has been that we relied on the filer to do the proof of service and notice of hearing. And the majority of all adjourned accounts were due to notice of hearing and proof of service. So when we require that the annual account is filed with the proof of service, then we do the notice of hearing and proof of service of the notice of hearing for the account hearing. It's been 10 times more smooth. I think the backlog has almost gone away. I think I have 2 months to catch up, and I try to stay on top. So yesterday was September's, and I will get all of September's done within the next week or so, and then do another month at the same time. And then we should be we should be done with all backlogged accounts before December. All right, so why am I hounding you on deficiencies? I think it's important that you understand how we're doing it, why we're doing it, and why you have to stay on top of it, whether you have a docket tracking system or your Outlook calendar. But the court staff are running them daily. The staff will issue 28-day notices for compliance. Failure to comply may result in administrative closure, referral to APS, CPS, suspension of the fiduciary, appointment of a special fiduciary, contempt, and or a bench warrant. And so there are big consequences for failing to comply. Let me just move this over. One of the biggest changes that you all are going to start to see is that effective October 1st of this year, the court will issue letters of authority that have an expiration date on them every year. Currently, it's looking like it'll be about a 421-day period that they're active. And the reason we're doing this is to ensure compliance, especially with conservatorships. The court will only issue new letters each year once the annual report and or account is filed. The purpose of that is, if you have letters and you take it to the bank and the bank puts it on file, they see that it expires. I'm making this up. In March of 2021 or 2022, they will cut off access if you don't provide new updated letters. And it's more effective and ensures the assets of the ward are more protected. I mean, I'm never going to be able to guard against every possible abuse of the system or funds, but it certainly is a way to ensure compliance. It also reduces our administrative closures. And so after looking at all of our dockets, this was a big hurdle for me to figure out. I looked at other courts, what they're doing, worked with scale, and this appears to be how other courts are handling this similar situation. So moving on to remote hearings, Judge Garcia and Judge Dunnings both have their Zoom hearings posted on our website as to what they'll permit and what they will not permit, and then where you contact someone for an exception to those rules. Again, the general rule is if it's contested, you're going to have to appear. If it's not contested, you can do via Zoom. Currently, Judge Garcia is doing the old schedule of 9 to 11:30 probate matters. That's where we're moving for him. He's doing 2 cases per 15 minutes. And Judge Dunnings is doing Thursdays all day. So hers are from 9, I think, until 3:30. As to my docket, I will have a courtroom, which is the referee room located on the 2nd floor in between Judge Garcia and Judge Dunnings' courtroom. It's the courtroom normally used by Rod Porter for juvenile matters. Every Friday, I will have that available for hearings and review hearings. In-person and remote attendance will be permitted. Account hearings, as you know, there are already paper hearings, but I've also established quarterly final account hearings so that those cases can move faster, get closed faster, etc. Excuse me, I have something in my throat. Again, look to our website for any updates. Oops, sorry. All right, so the big beast that no one really wants to deal with, I'm so sorry, is the new protecting personal identifying information. SCAO originally had the effective date of these court rule changes as being July 1st of 2021. And when I tell you it was probably more chaotic than the first start of the pandemic, it was because it was in 2 weeks after the court said, you're all automatically into phase 4. And then, oh yes, we're going to enforce this. So can you get everyone on site, make sure that you are redacting and have all these changes. It led to all of the courts having an upheaval. And I think ultimately the reason why it got extended to January 1st of 2022. So what is protecting personal identifying information? It was an attempt to make people's private information more secure. This has really been in the works for many years, and there's been pushback here and there, myself included, as to how the rule should work or be changed or modified. And the previous rules really were going to crush the court staff because it required us to redact everything, old and new documents, which isn't feasible. Gosh. So what I need you all to pay attention to in the next 5 months is to really hone in on your practice with your staff as to how you are submitting forms for filing. SCARE's updated over 200 forms, and at least 49 of them are probate. Majority of them are probate. And there's links here for you to go to the website. So what is PII? It's a date of birth, a social security number, a driver's license number, passport number, and financial account numbers is currently what the definition of PII is. So what does that mean? Anytime you see 1 through 5, you should have your blinders on and know that we have an issue. The final accounts numbers, goodness, really come into play with annual accounts or proof of restricted accounts. So what you will begin to see is that if you were here at our terminals and you're searching for records and you pull up the image, gotta get a cough drop. The staff have started to redact in our electronic software. We can always print it and see what the original document is, but we have a redaction tool to block out the PII. So there's different ways the PII comes here. Documents filed by someone outside the court. And it's the responsibility. And then when we provide, so they file it with the court, then we provide copies. Once we provide copies or access, we have to ensure that the documents are redacted. So that becomes a big burden. There are things that we will have to do to still have a certified record. For example, we'll change our stamp that'll say, pursuant to this court rule, this is the official public document, and we can certify that, but we can't give the unredacted out. All other documents filed or issued by the court on or after January 1st have to be redacted before we provide access. So again, that's a big burden on staff and time sucker. So I just want you all to be aware of that and have patience with us. These rules apply to anything filed, not just scale forms. So wills that have social security numbers on them, death certificates, which is, almost everything someone files here in probate court is PII, and it's a lot of responsibilities that are being put on us. So PII and relevant scale forms, there are essential 4 approaches they're taking with this PII. So they're either removing all the PII from the form, great, easy. The form you have and the form we get are the same forms that don't have PII. Require a separate PII. There's also an approach that requires a separate confidential PII document to be filed. I'm sure you all have seen that, but that's like the MC 97 or 97A. It's a supplement to your filings that has the PII. Those remain confidential and not, out for the public. The one that really is difficult and I have a lot of problems with is the 2 versions of a form. This is where forms are split and PII is included in one version of the form and PII is not included in the other. I think this creates a big records issue and certification issue, and I'll go over an example of that. And then the 4th approach is that the PII fields are left on the form. For most PII forms, it'll have to be redacted if we give copies. But there are hopefully going to be clear exceptions to that. For example, our guardianship orders have to have PII for lien information that we send over to the state police, or our mental health orders to CMH. So we're still awaiting guidance on that. So again, the creation of new forms, these forms must be used. It's not even until stock's depleted. It's a hard must. So the crux of what I'm telling you all now is to get familiar with these, use these, and know what you're doing. We're not rejecting any forms currently, if they're using the old or the new. Even if you filed a new form and you included, the MC97, which is the confidential information form, we would still accept it. We're putting that MC97 form as non-public. So just know you could start practicing it now and be in the habit, and we're happy to accept that. But starting January 1st, it's going to be a hard rejection. Let's see. This will let me do it. Maybe not. Okay, so MC97 and 97A, again, like I said, these are just addendums to any filing that you have. You would then put, the name, the PII information, et cetera, here, financial institution, et cetera, here. So with accounts, what I would behoove you to do is redact that account information on the financial statement and put it onto the PII form. Get in a habit of doing that, because it'll be extremely laborious for my staff to go through every financial record or financial institution. And that also is like your bond company, your surety is a financial institution with that account number. So if you can be very cautious about that, I would greatly appreciate it, because it's very tedious for our staff as well. So examples of 2 versions of the form. I can't stand this. But for example, let me see if I could. I have to share a different screen. All right, so the petition for assignment, this is the new form. I hope everyone can see this. So you have a separate petition for assignment. You fill out all this information, it's still the same, et cetera. And then all of this is all the same. But what you'll notice is that the order is not attached, and it's no longer a petition in order for assignment. It's 2 separate items. So you filed this, and wait, I got to get back to the best part of it that drives me insane. And then the order for assignment. Which is a 2-part. And the order for assignment, part 1, see the PII would be here. I'm just making this up. 5555. And then the judge would sign and date. This drives me crazy as well, because judges are not used to having their signature and date in the same line. But part 2 of this form, you can see the PII is blacked out here. So what the current instructions are for a petition in order for assignment is that you file the petition, and then you file this order for assignment, both parts. The court is to sign both of these, give the original that has the PII, which is the part 1, this would go back to the petitioner, and then the court would keep part 2 for a court record. Well, it's a big problem, because for certified copies, now we have two orders for the same thing that aren't the same for the court record, because we're not supposed to keep the first one. This is why it drives me crazy, is because A, now our court record looks incomplete, and B, I have 2 orders, the judge's signature with different items on it. So we're hoping that we get clarification. Currently, what we're looking at doing is just issuing 1. So if you filed 1 with us, we can scan it into our system, redact it, still give the petitioner a copy of the original one, not redacted, but have the one that was issued with the PII in our system with our, electronic imaging over to redact it for public view. The split forms is way too difficult and confusing and problematic, but if this is the way they keep going, just be aware of this. And each court may do it differently. Okay, so let me go back to my. Okay. So these are just some of the forms that are updated. It's quite impressive how many have been updated. But I will tell you, we have programmed our website so that every form that you're clicking on our court forms tab is linked automatically to scale. The exception to that would be our packets that are made, but we make sure that those are updated as well. So our packets have the most updated form, and then the links on our website are all linked to scale directly. So those will always have the most updated forms. My biggest guidance and advice is to look at Scale's website. There's a very helpful webinar that I've included here, but also to remember that effective January 1st of 2022, if it's not on the most recent scale form, it's going to get rejected right out of the gate. So for your client's sake, for everyone's sake, to save money and to be on top of it, know the rules, and please don't use the old forms. All right, best practices. These are just some tips here and there that we have noticed or just to throw out there. So exhibits, if you have hearings, please label the exhibits before the hearing. Petitioner's numbers, respondent letters. The use of scale forms, court rules require that if there is a scale form available for whatever you're trying to file, you must use that form. And so unlike circuit court, they could literally take a piece of paper, a napkin, and you could file it if it had a case heading, case caption, and meant filing guidelines. You have to see if we have a form on file with scale for that particular action. If we do, you must use that form. Signatures. So there is a new requirement that if a scale form provides an area for an attorney's signature, the attorney of record must sign that form. Again, it's only if the scale form has that area for a signature. And so going on to signatures, there are circumstances where the attorney of record signature alone is not sufficient for filing. And those are for an acceptance of appointment, an inventory, an account, sworn closing statement. Those all have to be signed by the fiduciary or trustee. And then a receipt of assets, which is receipt of property from conservator. That's an example. It has to be signed by the person entitled to those assets. So again, the attorney can't sign those alone and it be sufficient. Proof of service, if you all can just always remember when in doubt, do a proof of service, that would be great on all interested parties. And please make sure that the boxes are checked accordingly, whether it's first class mail or personal service. We already discussed the case code types. Make sure that those are on there as well. It could be rejected again for failure to include a case type. Hearing dates and adjournments. As you know, we do all the scheduling here in the probate court office. That's uncontested and contested. So in the event that you already have a hearing and you need to adjourn it, the court strictly adheres to MCR 2.503, requiring that a request for adjournment can be made by motion or stipulation, and it is based for good cause. The exception I would say is that if you have an uncontested matter on our docket and then it all of a sudden becomes contested, then clearly there's an adjournment, but that's by the court's doing. They're moving it to their contested docket. Again, deficiencies Already went all over that. Just remember to file the receipt of property from conservator or guardian when the final account is allowed. These are just some estate tips. A PR, oh, sorry. What am I doing here? Okay, so if the PR is a creditor, and how claims by personal representative against the estate for an obligation that arose before death shall only be allowed in a formal proceeding. So if a creditor is the PR and is seeking to have a claim satisfied for which occurred prior to the decedent's death, it can't be done informally. It has to be allowed in a formal proceeding by the court. On that note, creditors also have the ability and standing to file after 42 days after death for appointment on an estate matter. Small estates, there's two big ways, the small estate affidavit and then the petition in order for assignment. These are great ways to go about getting a probate estate handled so far as the amount is at or below the jurisdictional requirement of $24,000 currently. All right. So future thoughts that I just always hone in on, and it became really apparent with this pandemic, is that Michigan doesn't have a family consent statute. We're one of 8 states that doesn't have a family consent statute. So why do I say that? Why do you care? The number of guardianships that came across my desk for ventilating somebody or a feeding tube during the pandemic was astronomical, because they didn't have a dual power of attorney, regardless if they were married or not. And it's because certain hospitals have certain risk liability and policies as to who can consent for different medical procedures of an individual. And some are very rigid and say you have to get a guardianship. So please, if you are looking to do estate plans, or even your friend down the street, it's really a prudent thing to have a power of attorney in advance. So that's just a side note. Mental health is, again, a huge issue. There's a lot of stuff that we have to look at with our laws, our systems, but it's going to get even busier here in Ingham County. And the reason being is that McLaren is opening its new facility in 2022. And the word on the street is that their old facility will be converted into psychiatric care. So just an FYI for that. Other than that, thank you all for this time this morning on Wednesday morning. If you have questions, I'll open it up. But also, please know that you have my phone number, my email. If you need anything, I will try to get back with you as soon as I can. And this is all, after all, it's not my court or the judge's court, it's the people's court. And I certainly want to help to the extent I can. So thank you all. And then is there any questions?
Thanks, Morgan. Yes, definitely. Let's take questions. I do have a few questions that came through on the chat that I want to bring up for everyone. So on wills and death certificates that have Social Security numbers on them, are we needing to redact them before they are filed, or is that something that the court is going to be doing?
No, I wouldn't. No, I wouldn't redact those, because the court will come in and redact those. Plus, we need to also verify. So if maybe there's a will that we have for safekeeping with the death certificate, it's usually the last 4 that I can say, okay, this really is John Smith. So we'll redact from there. Plus, I think it would be not the prudent thing to do for you to touch a will or make any changes or etc.
Perfect. All right. Anyone else have some questions? We can kind of just go through and, whoever has questions, unless someone's talking over, but I'm sure that we can handle that. So go ahead. If anyone else has questions, go ahead and ask.
Hey, April, I just want to say that the packet, that the PDF or the PowerPoint that Morgan was using, she did email to my office right before the meeting, and I'm going to forward that out to the whole section so that they have it also.
And Sally, I'll send you, because I found one typo, I have to fix it, it'll drive me crazy, but I'll send you the PDF one or the regular one too.
Okay, thanks.
Well, I'm just curious, Morgan, please, are we ever gonna have e-filing again?
So I'm a huge proponent of it, and I get it. Chief Judge Garcia, when he reads the court rules, and e-filing is a term of art, and so filing by email is not what was contemplated by the court rules. I do think it'll likely be revisited when we have a change of leadership. Should it go that way? It was difficult for the staff at first, but we had a really good business practice and business rules to address the e-filing. I hope that it comes back. I'm looking at different technology services to actually not wait for my file and maybe have some system in the interim until we get up and running with my file. So I hope to see it come back. I don't know when, but I am a big proponent of that.
Perfect.
Thanks, Morgan.
And we got another question through the chat. So it said that Morgan's notes say no real property for petition and assignment, but I think that it was just the smallest states that your notes said no real property, right?
Right, the small
Yeah.
state affidavit. The petition in order for assignment can be real property.
Yeah, perfect. Yeah, so it's just a different form, Michelle, for your question. That was the no real property. So when you look at the PowerPoint, I would go back and visit that page. Anyone else?
Is there anything that the staff is doing great that anyone likes or wants to point out, or areas you think we could improve, etc.?
Yeah, I think that, I mean, everything from what you guys have done, honestly, it was hard to get used to for that first year, but it's made things much smoother. So at least that's my opinion, and we definitely appreciate all your hard work. Heidi has another question, but everyone, go ahead on anything that you want to say for Morgan's question there. I know it's hard in a virtual form. Heidi, if you're on, go ahead and ask your question. Michelle says staff has been great at responding to emails.
Good.
Heidi says she has a question on wet signatures, but I don't see her on here. If you want to ask your question in the chat, Heidi, I can ask her.
Well, I'm assuming taking a guess on whether or not it should be an original signature when you're sending it in, as to what she means by wet signature. See, from my standpoint is that now we have the ability to have electronic signatures, and electronic signatures could be something as silly as, a /s/. And so arguably a copy could be an electronic signature because they've sent it to you via PDF, or they've signed it electronically and it just happens to look just like their signature. So I'm not rejecting items for that. I think it makes it very difficult to practice in modern times. And the reality of it is as the attorney or as the person signing the document, they're attesting under penalty of perjury. If someone didn't sign it, they're going to object and challenge the validity of it anyway. And so we should not make it more difficult.
Perfect. Yeah, I think that answered it for Heidi. So thank you. Anyone else have questions?
Hey, yeah, I just want to say, April, I mean, the changes that I've seen in the last few years with Morgan there have just been phenomenal. She has solved so many concerns and issues that I had prior to her taking over, and she has done so many things that I never even thought of. So it's just amazing to sit here and watch through her PowerPoint how many things she's thinking of and looking at that the rest of us either take for granted or just aren't even aware are issues. And I will say that she has trained people well because, you know, Ruth Ann is over at Eaton County now, and she was the first one to nail me on those personal identifying information forms. And so that was trial by fire for me. And so now we just automatically do them on everything in every county. So yeah, I can't say enough good things. It's just been refreshing, to say the least.
Well, thank you. This has definitely been the most challenging job I've ever taken, but also probably the most rewarding. Sometimes the hardest is the most rewarding, but it was a horse of a different color when I came in here and saw, you know, administration and staffing and retention of staff is so vital to the continuity of service. And these are people who don't have law degrees. Some have high school diplomas or associates, maybe some bachelors, but making it an atmosphere that people want to stay and want to be loyal and want to work is very important. And having constant turnover only continues chaos in the office. And so, you know, if you interact with someone in our office, if you send a nice note to them or copy me or whatever it may be, it means the world to them to have that as well. But thank you for saying that, Sally.
Well, and just having the processes and the procedures in place, when you do have turnover, it's got to make things so much easier to transition to another person because they're learning the process. And so they should be able to step into that rather than just having somebody train them on how they do it. Because that's what you run into, you know, at other places.
That's what it was. It was a word of mouth here. And so we have now business rules and procedures that staff can refer to, and it makes it so much easier for all of that.
Yeah, and for us, because we know what the rule is instead of just trying to figure out what the rule is going to be that day, depending on who we get at the counter. So, and you all know that I have been, you know, very vocal about my issues with the previous administration there. So it's saying a lot, let me tell you that. It's amazing.
Well, thank you. But again, it's not my court, it's the people's court, and it certainly wouldn't be here without the attorneys that practice in it. And so it has to be run so that everyone, and there's always room for improvement. And honestly, if you have areas that you think we can improve, tell me. I mean, I'm so open to it. And if we mess up, we'll take responsibility and seek to fix it as soon as possible. But again, thank you all for your support.
Well, it's frozen on my end. I'm assuming it's frozen on everyone's end. Okay.
Same here.
Well, that's good. It happened at the end. We'll give Morgan a minute just so we can thank her. But let's see here. But thank you all for bearing with us. You know, it's been a few years. About what it took. Okay. Brought my dog into the office today. Just thank you for the start to the ICBA probate and trust section. You know, we wanted to be in person, and so we are just very thankful that you guys have all joined us virtually. And we don't know from month to month. The board will meet every month to determine if we are going to be meeting in person ever. So for right now, this is going to be our platform. More than likely next month as well, for sure. But we'll revisit it, you know, here and there. But Sally and I are very grateful to everyone. If anyone else has any other questions we can share with Morgan, go ahead and email us, ask right now, however you guys are comfortable. Well, if no one has anything else, thank you so much. And we will see you guys next month.
Thanks, everyone.
Thank you.
Yeah.
Bye. All right. Bye-bye. Oh, hey, Morgan,
Bye.
Here we go. So if everyone just wants to thank Morgan, I know we can't really do round of applause or everything like that, but we really appreciate it. So
Absolutely.
thank you so much, Morgan.
Thanks.
Thank you.
Take care.
Take care.
All right. Well,
you.
thanks so much, guys. Sally will send out that email, and we'll go from there. So thanks so much. You guys have a great rest of your week.